Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Okay, we are back in the studio with Kentucky workers' compensation attorney Jeff Roberts, and today we're going to talk about a sticky situation. It's when you're injured, but you find out your employer doesn't have workers' compensation coverage, and that's a big deal. Jeff, welcome back to the studio.
Hey, Jim, how are you today?
Buddy, I'm doing great. Let's jump into this one because this is a scary situation. I mean, because you may think that you don't have any options here, but that's not always the case. And quite honestly, the employer may have a bit of hot water to dig out of it this time. So there's probably three different reasons. One, as an employer, I never signed up for workers' comp. Number two, I had workers' comp coverage, but I let it lapse, and that was probably the time you got injured. And oh, by the way, the third option, maybe I don't see you as an employee. You're just contract labor. You're a 1099 employee or a 1099 worker, so I don't really have to cover you anyway. At least that's what they're going to say.
Correct. And that's typically the three areas where you see there's no workers' compensation coverage. You have some employers who never purchase workers' compensation insurance coverage from there for whatever reason. It can be that they don't think they can financially afford it, even though it is required coverage. An employer that has one employee subject to the Workers' Compensation Act is required to have workers' compensation insurance coverage.
Hey, I didn't know I needed it.
And that's, you see that to some extent. And usually where I kind of see that is somebody who starts off doing work on their own, and then as the business grows, they hire somebody to help them do the work, and they really never did go talk to an attorney or an accountant about how to set up a business and start it. They just kind of did it maybe on the weekends. They had another job, and that's where you tend to see the people who didn't know that they had to have workers' comp. There are some who absolutely know they have to have workers' compensation coverage and just choose not to have it and just tell their employers or the employees, I don't have workers' comp coverage, and so if you get hurt on the job, too bad, is what they tell them. And those you really tend to see them trying to do the 1099 process that you talked about, where they say, well, you're not an employee, you're an independent contractor. I'm not going to take taxes out. I'm not going to provide workers' comp coverage, and those things. And they give they pay the worker, and then at the end of the year, they give them a 1099, and they don't pay unemployment. They don't take out the FICA taxes. They don't do any of that, and try to call the person an independent contractor. And then the one that's the much rarer one, but it does occasionally occur, is where the coverage lapses, and they don't have insurance coverage because the coverage lapses from that. Now, a third option or a fourth situation that I've actually seen a few times, and this occurs when where I've seen it is companies outside of Kentucky who do work in Kentucky, construction type companies that hire union labor. So if a company down in Tennessee is hired to work at Murray State University, and Murray State should be, and the state typically requires proof of workers' comp coverage, using this as an example, but they're hired to do some work, build a building at Murray State University, and they hire labor from the labor hall in Paducah, and it's a Kentucky worker. And they have Tennessee workers' comp coverage. They don't have Kentucky workers' compensation coverage. And this injured worker's hurt here in Kentucky, never been to Tennessee, never worked in Tennessee. They got a Kentucky workers' compensation claim, and the employer doesn't have Kentucky workers' compensation coverage. So those are where I normally see a lack of coverage. And there's a couple of different things that come into play from that standpoint. First thing to remember is if the employer doesn't have workers' compensation coverage at all, you still have a workers' compensation claim that you can pursue. If the employer,
That's good news. I mean,
yes,
it's not game over.
correct. If the employer is truly uninsured for workers' comp purposes, then Kentucky has a fund or agency called the Uninsured Employers Fund. That agency is funded by by every employer who pays workers' compensation premiums in Kentucky. A portion of the premiums go to fund that uninsured employers fund. So if an employer does not have coverage, you still have the claim that you can pursue and get the damages that you're entitled to under the workers' compensation law, including the medical coverage, the lost wage benefit, and permanent disability benefits, vocational rehabilitation, all of those types of damages that you could get if they had insurance company, you can still get. It doesn't affect what you're entitled to under the workers' compensation laws. It just changes who's responsible for paying that. And that doesn't let the employer off of the hook, because the uninsured employer can come back and pursue a claim against the employer for what they've had to pay out. And I've seen them do that frequently in cases that I've handled for employers that were against employers that were uninsured in the past. From there, so you're much better off if you're an employer to get workers' compensation insurance coverage there. Now, there are some employment that is not covered for workers' comp purposes. Agricultural work is not required to have workers' compensation coverage. So, if you're working on for a farmer and have an injury while you're out in the field, if you're putting hay out in the field and cows hit you and knock you down and cause you to break a leg or something of that nature, that's not a workers' compensation claim, because agriculture is excluded employment under Kentucky law. There's a caveat to that. I've said multiple times during these podcasts, there's an exception to every rule, and that's about true to some extent. If the employer has any migrant workers, the agricultural farmer has any migrant workers, federal law requires them to have workers' compensation coverage. And I've seen farmers who do have workers' comp coverage because they have the migrant workers, and the coverage extends to all of their employees, not just the migrant.
That was my question.
Employees.
That was my question. So if they go into that realm of, hey, I'm going to hire migrant workers, then they have to have comp for every one of their employees.
Not necessarily. No, they just have to have. I think federal law just requires it for the migrant workers.
Oh, okay.
But most of the time, the comp carrier is going to write it for the entire thing. And I've never seen one that was just for migrant workers only. Every time I've seen it, it covers every employee that the farmer had. So, at least my understanding is, and I don't do migrant worker law, so I take it with a grain of salt to some extent, but I know they require workers' comp coverage for migrant workers. Most of the carriers, when they write the coverage, it's just going to cover all the employees. I've never seen any policy say we're going to cover these employees, but not these employees. Right. And I don't know that they could actually write a policy like that in Kentucky.
And that's kind of interesting, because workers' comp law is state specific, but in this situation, federal law actually gets involved, or at least federal regulations. And
federal law requires that coverage.
Yeah.
So, and Kentucky law has always said that even if you're an employer that is exempt and do not have to have workers' comp coverage, you can elect to be covered under the Workers' Compensation Act and provide workers' compensation coverage and get the benefit of that. The benefit of it is you can't get you have the exclusive remedy of the Workers' Compensation Act, so you don't get sued civilly.
You can be proactive that way.
Exactly.
Step into the ring.
Exactly. Yeah. And so farmers have always been able to purchase comp coverage and have their employees covered and protect themselves from being sued civilly by a worker that gets injured. It's just federal law requires it for if you have migrant workers.
Well, you and I are both graduates of Murray State University here, and I remember when I was here on campus, during the summertime, a lot of my buddies would head off to the tobacco fields, and they'd have a couple farmers would hire them, and they'd go out and cut tobacco. So if one of them happened to get hurt, they weren't technically covered under workers' comp.
Correct.
Okay, that's
Yes,
interesting.
back in the day before we had the migrant workers up here. I mean that's.
I'm not that old. Old enough.
Yes, you are. I mean when I grew up, I grew up here in Western Kentucky, and that's from time I was 11 years old. I was working on a farm, hauling hay, setting tobacco, hoeing tobacco, topping, and cutting, and all of that. So, working on a farm is kind of it's normal for Western Kentucky kids.
Absolutely.
Especially back in my day. Even if you didn't live on a farm, I didn't grow up on a farm, but I worked on farms from a young age forward. From there, and I think I was probably as happy to see my father-in-law retire from tobacco farming as anybody, because after being a lawyer for several years, that tobacco patch got a lot hotter than I remembered it when I was a kid. But and at 45 years old, cutting tobacco was a lot different than when it was when I was a kid as well. But back then, no, they weren't covered under the Workers' Comp Act. And frankly, when I first started practicing, 29 years ago, I don't know that I can recall any employer, any farmer who had workers' comp coverage. There may have been some, but I just didn't know that. Right. Now, I think some of the you would see it up more in the Lexington area. Some of the horse farms would have workers' comp coverage, even though they weren't required, because horse racing in Kentucky is agricultural. So they weren't required to have it, but a lot of times they would have it. But getting back to if the employer doesn't have it, doesn't have workers' comp coverage, one other provision there is if they don't have workers' comp coverage, and they should, then they don't get the exclusive remedy of the Workers' Compensation Act. So you have the workers' compensation claim against that employer, which would be paid by the uninsured employers fund if you're successful. But if there was negligence that caused the injury, then you also have a civil action where you can recover pain and suffering against that employer, which is another reason why employers that are required to have workers' compensation should have workers' compensation, because you get that exclusive remedy provision. And if you fail to purchase the compensation coverage, you give up that exclusive remedy provision.
And that's a lot of legal exposure and financial exposure for an employer.
Can be, yes.
Yeah, very well.
Absolutely.
Can be. So what happens if the coverage is lapsed? What happens if the coverage is lapsed? And, hey, I had it and I'm still trying to get it, but, I'm kind of in the middle here and it was just bad timing.
The same situation is the uninsured employers fund would kick in and pay in that setting. And, those are the easier cases to a large extent. The employer is given a W-2 to the person. There's no doubt that they were an employee. They were shown as an employee on the coverage 3 months ago.
You've cleared that bar.
Yeah, and so those are usually the easier cases. The uninsured employers comes in, looks at it and says, okay, yeah, and the person, once they find out they're uninsured, the employer typically fixes the problem as soon as they realize there's a problem there. And sometimes that problem could be, they send it in and for some reason didn't get processed correctly. They may have paid the premium and for some reason there's a snafu at the insurance company. And if you get that corrected, then the insurance company pays and says, yes, they really weren't uninsured. But those are the easier uninsured employers cases because they're not really denying that the person's an employee. The more difficult cases are the ones where they give the 1099 and try to say that the person is not an employee of mine, they're an independent contractor, and so I didn't have to have workers' comp coverage and they're not covered by workers' comp. And those are cases that, unfortunately, you have to litigate pretty much all the way to a judge's decision before the person gets the workers' comp benefits that they're entitled to, because the person is taking that position that they're not an employee. Kentucky law is and has been for as long as I can remember a state that says, you can't just say somebody's an independent contractor. We're going to look at the true relationship of the parties and not just let you say, we're going to call them an independent contractor, but we're going to treat them like an employee.
Kind of cheat the system a little
Try
bit.
to cheat the system so you don't have to pay workers' comp coverage and unemployment and take taxes out and do all of that. And most states, I think, have that same kind of provision that they say they take it. You don't get to decide. The law decides based on what your relationship is from that. And there's a variety of factors that you look at in making that determination of whether the person is an employee or is an independent contractor.
Right.
If it is if you have a situation where the supposed employer tells you what time to get to work, what you do when you get to work, what job, where the job site you're supposed to get to, provides most of the tools, obtains the employment, and essentially directs everything like an employer would direct, that's going to be an employment relationship setting.
It's the control over the activity.
Yes, control over the activity. That's going to be an employer-employee relationship. If it is a situation to where, and we'll use a common example, but you've got somebody who is a general contractor who's building a home, and they put up the walls, and they have employees that put up the walls and the rafters and everything. But then they hire somebody who does nothing but roofing, and they come in and say, okay, give me a quote on doing this job, and they give a quote, and they're paid by the job, and then they go, and that roofer goes to somebody else and works for them the next week, and somebody else the next week. That's truly an independent contractor. Whereas, if I'm a general contractor and I've got somebody that I have roofed this place one week, and then they roof this place this week, and they roof this place, and I'm paying them hourly, but I'm directing the job site that they go to, what they're doing, that instead of them being able to go work for whoever they want to go work for, they're always working for me. That's more of an employment setting, and you see that in a lot of you see it in construction trades where people are called and tried to do the 1099 independent contractor route. Now, frankly, your more reputable employers do not do that. More reputable business do not do that. They treat the employees the way they're supposed to be treated. From that, I've dealt with it in a variety of settings. In fact, I've got a published case from the Kentucky Supreme Court in regard to a cab company setting where my client was a cab driver, and the cab company tried to set it up and say they were independent contractors, but they controlled everything, provided everything, told them where to be when they report to work, and set the fares that the people charged, all of that stuff, and it went all the way to the Kentucky Supreme Court, and the Kentucky Supreme Court agreed that yes, my client was an employee and was entitled to the workers' compensation benefits. So.
Again, a lot of it is controlling the activity during the day when they're on the clock, and that's, and this is unfortunate. But the good news is, if you've been injured, go talk to an attorney. Go let them figure it out, because it doesn't really matter what the employer says. It doesn't really matter what the claims adjuster who's working for the employer says. You have legal rights.
Correct.
And Kentucky workers' comp is fairly generous, and it's fairly broad. And even if you're working outside of Kentucky, but you're hired by a Kentucky employer, that's a big. I think earlier in this episode we talked about, well, maybe a company out of Tennessee comes into Kentucky and hires some labor. Well, if your Kentucky job or Kentucky employer gets a job in Tennessee, and so you go across state line down there and you get injured in Tennessee, you still can have a Kentucky workers' comp claim.
Correct. Exactly. You can have a Kentucky workers' compensation claim, and I've handled those type of cases frequently. Some trucking company, one trucking company locally has a part of their employment contract is, if you're, regardless of where you're at, your claim will be covered under Kentucky law. So, I've represented clients who were injured in Texas, Minnesota, New Jersey, Maine, all over. And, they may have a case in Kentucky and a case in another state. And if that's the case, what I normally do is call an attorney in that other state, find out which state's got the best benefits for my client, and then the case is pursued. If the other state's got the best benefits, I tell the potential client, go talk to these folks and let them handle it there because that's better for you than Kentucky is. If Kentucky's better, we pursue it under Kentucky. So if you're based in Kentucky, your employer is based in Kentucky, and you're injured outside of Kentucky, you probably still have a Kentucky claim. So talk to me or another Kentucky lawyer to find out. And it may be that the other state's law may be better for you, and if it's allowed under that state's law, fine, you pursue it under that state's law, and I'll try to put you in touch with a good attorney in that state to handle the case. But if Kentucky's better for you, then we can pursue it under Kentucky law from that standpoint, and vice versa. If you're injured in Kentucky, if the injury occurs in Kentucky, you're based out of Tennessee, but you're working in Kentucky, your employer's based in Tennessee, but you're up here on this job and you're injured in Kentucky, it's a Kentucky workers' compensation
Right. So
claim.
there are a lot of ways to make that happen, and with that uninsured employers fund, I mean, there are a lot of safety nets here. So just because your employer says, "Hey, sorry, I don't have comp coverage for you," it doesn't mean, again, that's the final answer. There are a lot of resources here, and it's one of those things. Get in touch with Jeff. Call Jeff and just say, "Hey, look, here's my situation," and let him use 29 years of experience to say, "Well, okay, let's peel it back a little bit and kind of look at the facts and get a qualified opinion."
Yes, absolutely.
And it doesn't cost you anything to call you.
It doesn't cost me anything to call me. It doesn't cost me anything to come in to see me initially. The initial consultations are free from there. And, most of the time, if you're getting a W-2, you're an employee. If they don't have comp coverage, we're going to be able to get you the workers' compensation. Most likely. Don't like talking absolutes. Most likely going to be able to get you workers' compensation benefits, even if they don't have insurance coverage, because we can do that through the uninsured employers fund. If they tried to treat you as a 1099 employee, independent contractor, and say, well, you're not covered by workers' comp because you're an independent contractor. During my career, I've seen that several times. Very, very few of those situations that I have actually thought the person was truly an independent contractor. Most people know if they're an independent contractor, so it's very few of the times that I thought the person that come in to see me was truly an independent contractor. In fact, off the top of my head, I can only recall that occurring one time in a situation, and probably the maddest that my office staff has ever been at me, because it was a driver who drove stage materials for a country music star that is, I'm not going to mention the name, but widely considered a quote-unquote sex symbol male country music star. And my staff really wanted me to take that case and take that guy's deposition here in my office and make him come to Murray, Kentucky. And I told them that was not going to occur, even if I did take the case. But that was the maddest they've ever been at me, I believe, anyway. But though that's truly the only time that I ever saw one that I thought was a true independent contractor setting that I can remember off the top of my head.
Well, let me ask you this. And again, a lot of smaller operations may try to say, hey, you're just contract, you're not actually on the books. Even though I'm paying you with a company check, does it make any difference if they're paying me in cash or a company check? I may think I'm getting a W-2, but ultimately I get a 1099. That's a big difference.
Yes, it's a big difference if you're getting a W-2 versus a 1099.
Yeah. But how they pay me, does it really? That's not the rule.
How they pay you doesn't matter. It's
Good.
If they're paying you, what comes in if they're paying you cash, documenting what your wages are going to be much more difficult. So if they pay you by check, we can subpoena and get the canceled checks to find out
Yeah.
what your wages were. And I've had employers at times tried to deny that they've ever paid the person because they paid them in cash, and they said, "Well, no, they weren't an employee. They never worked for me." And I've had to have people they done work for come in. No, that guy was the one that built my barn.
Yeah, exactly.
And, they were this whole crew was there, and he was one of them that was there, and I paid this guy for it. But all of these people were there working.
Yeah, well, and that comes back because by establishing the wages, now when it comes to temporary total disability payments, TTD payments, that's a formula that has to do with the average weekly wage. So again, being able to establish that, and that's some of the forensic stuff that you do here.
Correct.
Really, again, is what experience enables you to accomplish.
Right.
Sometimes it doesn't work, but more often than not, I think there are ways to kind of get at the information you need to get at.
Exactly. You got to track it down by different sources, but a lot of times you can track it down by different sources. If you're getting paid in cash, you need to be keeping track of that yourself.
Absolutely.
Because for a couple of reasons. One, hopefully you won't get in there injured on the job, but if you do, you've got documentation of what your wages were. More importantly, you're supposed to be paying taxes on that income, and if they're treating you as 1099, they're not taking taxes out. And so you need to be keeping up with it so you can take care of that and file the taxes the way you should be filing your taxes, which, I understand some people don't do that like they should from there. And I've talked to folks who haven't done that in the past, and then they become disabled and they come in to see me and they say, "Well, I've worked all my life and I can't," and they're telling me I can't get Social Security disability benefits. I talked to them about the work, and they've worked under the table, so to speak, cash check, but they didn't pay taxes in on it. And they may have an SSI claim, but then their spouse's earnings knock them out of that eligibility. And I have to have a hard conversation that, unfortunately, because of the way you chose to work and you're not filing taxes on it, no, you don't get Social Security disability because you didn't pay into Social Security disability.
Right. So. And sometimes these are hard discussions, but more often than not, you don't take somebody's word for it. Go talk to the attorney. Let the attorney really look at this and understand the situation, and then look at the facts. And that's really where things turn is, well, they told me. That doesn't really mean anything. It's like saying I got injured, and if you don't tell the employer within 24 hours because that's company policy, that's not state law.
Right.
And we talked about that in the previous episode. I mean, there are a lot of things out here that you as a 29-year practicing attorney have seen, have encountered before, and know how to deal with effectively.
Correct. Yeah, and that's the way. One thing that when I started practicing, and I knew I had learned, and thankfully had a very good mentor who I worked under for first 8 years of my practice until he passed away, and he taught me a lot. But when thinking back on how long it took me to do things when I first started practicing, because I didn't, I was learning, didn't know it, and those things are just easily accomplished in a very short order now, and it's just I think back on that, man, it took a lot longer to do things when I was younger than it does now, and that's part of what you pay for is the experience in training and that. And when you come see me, you get 29 years of practical experience.
And you made a statement, that's what you pay for. But, workers' comp's a little bit different because you work on a contingency fee.
Correct.
And you want to explain that real quick?
Yeah, contingency fee is I get paid a percentage of the recovery, and it's contingent upon recovery. So if there is not a recovery, then there is no fee. And in Kentucky, actually, for workers' comp purposes, the percentages are set by the statute. I don't have control over those. And I tell clients all the time when I'm explaining to them about what the fee is in a workers' compensation claim that the politicians made it a whole lot more complicated than I would have made it. But I don't have control over the percentages I charge in a workers' comp case. It's 20% of the first $25,000, 15% of the next $25,000, and then 10% of anything over $50,000 with a cap on the fee as well.
And that's important. There is a cap on the fee.
Correct.
Regardless of what the recovery is,
yes.
It can go no higher than whatever the
and the cap's $18,000.
Yeah.
Now that's what the cap is right now. And there are cases where there's one case that comes to mind that I've resolved in the fairly recent past where the funds that my client's ultimately going to receive are we end up being into the seven figures, my attorney fee's $18,000.
Yeah, regardless.
Yeah, regardless, from that standpoint. So, and that's somewhat important because, on hourly rate cases, you go to an attorney who's not as experienced, they're going to charge a lower hourly rate, and you can make a decision, okay, do I want to pay a lower rate, less experienced attorney, going to take a little bit longer, more experienced attorney, pay a higher rate in a workers' comp claim or personal injury case of any kind. My fees are basically everybody's going to charge the same fee in a workers' comp case from that. So you can go to somebody who's got 1 year of experience. You can go to somebody who's got 29 years of experience. You're paying the exact same amount.
Right.
You're not getting any break going to somebody who has 1 year of experience or going to a firm who signs you up and then farms you out to somebody who has 1 year of experience or 2 years of experience when you can get somebody who has nearly 30 years of experience.
Right,
So.
right. No, that makes a lot of sense. The Kentucky Bar Association always watches, what lawyers say, especially on advertisements and things like that. And even though you're working on a contingency fee, there are often, because you're fronting the money for those cases, you're paying for the doctors and the medical experts and their medical reports and different things like that. Sometimes there are case expenses along the way, and you front that, which is, again, that's your bet, right? You're
Correct.
taking the case because you think you have a good shot of winning this case.
Correct.
In the unfortunate situation where maybe you don't prevail, maybe you lose the case, does the client still have to pay those fees?
Not when they hire me. Some attorneys do charge the fees, but still, or expenses still. I do not do that. When they come in to see me to talk about a case, and there are some cases going in, I know, okay, this is a, there are some cases I know we're going to win. It's just a question of how much. There are some cases that, especially like these cases that we're talking about, where there's, they may be claiming that you're an independent contractor, and if we lose, it's not a question of how much; it's a question of do we get anything or not, and then how much we get if we do get something. Those cases, when they come in, a lot of times I can look at it and say, yeah, I've got a real strong chance, 75% better chance we're going to be successful in this case. Some of them are close calls. And I know that going in, and sometimes I take the cases that are real close calls because I think it's the right thing to do and I need to help somebody out in that regard. But when they come to me and I tell them, okay, I think this is a case, we need to pursue this, they're doing that based on what I'm telling them. And then to turn around and say, well, okay, yeah, I thought it was, but, here I spent $1,500 pursuing this case and we've lost, pay me back my $1,500, even though you only pursued it based on my advice to you. That just doesn't sit right with me.
Yeah.
That's not the way, if I take my car to a mechanic, the mechanic tells me I need to replace whatever sensor on it. They replace the sensor and that doesn't fix the problem. And then they say, well, I need to do this. It's always irritated me that I got to pay for the sensor. And so I don't do that. If you pursue the claim because I tell you I think you've got a legitimate chance of being successful in this, I'm the one who's going to eat that loss if that's the case. You're having to live with the effects without getting compensated for it. I take the loss of the money because you wouldn't have, that money wouldn't have been expended if I hadn't told you I thought we had a decent chance of being successful and I was willing to take the case for you. Well, I just think that's the proper thing proper way to treat people.
Well, it's your name on the door.
Correct.
And they're hiring you.
Correct.
And that's, that's a big difference, I think, sometimes.
Yeah. And that is another side of I practice a solo practice. When you hire Robert's Law Office, you get Jeff Roberts to represent you in that. And that was when I did work for that other gentleman, that came into play sometimes when I would talk to a potential new case before I become a partner in that firm. If it was a close call, I would go talk to him because it was his money that was on the line at that point. I was working, as an employee for him, learning. It was his money, and if we weren't successful, he was going being out. So he was the one making that call from there. So when you come to me, I can tell you then, and there's sometimes I'll tell people, I say, this is going to be a very, very difficult case for us, but I think we need to pursue it, and this is why. And clients can say yes or no. And there's sometimes I say, unfortunately, I tell people sometimes I think our chances of success just are not there, and I just can't get involved in it.
Right.
And that's what people need to hear if that's the truth.
And of course, they can go to another attorney and see if the other attorney has a different opinion. But
Correct.
But they can,
and I strongly encourage people to do that.
Absolutely.
Whenever I tell them it's not one I can get involved in, or if I've told people I don't think you've got a case here, but go talk to somebody else and let them look at it as well, because they may see something that I'm not seeing from that standpoint. And I've had people who come to me that talk to other attorneys before, and they just wanted to get a second opinion on it as well. Don't mind that a bit. And they come in. Most of the time, the attorneys and I agree that, unfortunately, we're not going to be successful, or at least the odds are we're not going to be successful in the case. But maybe I see something that they didn't. So.
Right. Well, Jeff, I know that was a little bit of a digression from today's topic, but I think that's important information for people listening, and it's one of the things that makes this law office such a benefit to this community and in this area of the state. Is just realistically, I get to deal with you, I get your experience, and I get to let you make these calls rather than being shipped out and farmed around and not really know who's handling the case at any given time. Jeff's got the ball.
Correct.
And I really like that about this law firm. So, Jeff, I know you got a lot on your plate. I know you've got a busy schedule coming up. I walked in and you were working on some pretty important documents when I got here. So let you get back to that. Thank you very much for your time. And friends, I appreciate you listening. And we'll be back in a couple of weeks with a new episode.
Thank you.
Thank you. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.